we have a special guest, Alex Jacobson, joining us. Jan and Kim, do you want to introduce yourselves?
Yes, hi, I'm Kim Anderson from Anderson and Boback.
Good afternoon, Jan Boback, Anderson and Boback. It's great to be here and great to see everyone.
Great.
Thank you for having me.
So do you want to tell everyone why you're in your car, Alex?
I will share that. I mean, I think we're all just doing what we can these days. I've got my son on a play date and, socially distanced, of course, and we're just doing what we can.
Good.
Absolutely. So we asked Alex to join us because she has started her own firm that specializes or concentrates, I guess, in mediation for family law issues. Alex, how did you get into mediation?
Sure. So I was practicing at one of the larger divorce firms for about 12 and a half years, doing exclusively matrimonial and family law work. And really towards the latter 2 years of my practice, became very dissatisfied with being in the courtroom. I didn't enjoy the adversarial nature of the practice and really wanted to take advantage of what I was finding to be a more successful way of reaching resolution in even high conflict cases. And so I launched this mediation practice doing exclusively matrimonial and family law mediation. So I no longer practice. You won't see me in a courtroom anymore. And I do only mediation, both attorney assisted as well as unassisted. And we can talk a little bit more about what that means. Parenting matters, financial matters, you name it, I'm ready to do it.
Good.
Awesome. And we've loved working with you and referring cases to you as a mediator. Obviously, we think you do a really solid job.
Thank you.
So how has everything been with COVID-19 for your mediation practice? Have you been busy?
Yeah, at the beginning when everything happened, there were quite a bit of parenting related matters that came up in terms of families trying to navigate I'm following more strict social distancing guidelines than you are, or what do I do if my former spouse is an essential worker and is going to be exposed? How, if at all, is that going to impact my parenting schedule? How does my support need to be addressed in light of the fact that, I may have been furloughed or, may not be receiving my full compensation. And so there were some very acute, immediate COVID-related issues that needed to be addressed. As it relates to just your ordinary run-of-the-mill divorce cases, I would say sort of at the beginning of COVID, things sort of stopped. People were not necessarily keen on the idea of getting divorced by Zoom. Now, after thousands and thousands of Zoom sessions that we've all done and hours logged looking at squares, I think people are far more comfortable with the remote mediation idea, and have also recognized the silver lining of it in the sense that, people are mediating in the comfort of their own home. They are not forced to drive downtown, park in the loop and be out of their creature comfort surroundings. And that's a real benefit for people who are, feeling the tough emotions that may be felt when going through a divorce.
You think you'll continue doing mediation by Zoom afterwards?
I really do. I really think that people are recognizing the benefits, the efficiency. I mean, part of the benefit of mediation, reason number 164, is the efficiency. It's not just, cost and it's not just cost in terms of not being involved in litigation, but the fact that we can do this. I'm in my car right now, somebody in their office, somebody may be at home, and trying to coordinate schedules becomes far more simplified when people just need to open up their computer and connect to a hotspot. And so I do think it will continue. And I think that goes not just for mediation. I think that goes for many different industries and, professional service type practices. But, even in the courthouse, people are continuing to be able to take advantage of remote procedures.
Let's take a step back. You mentioned you were becoming dissatisfied. Let's talk about that. So we're in the trenches here, right? I mean, that's what we do. We're in the trenches. We're in the courthouse. Of course, not now. Everything's been being done by Zoom.
You're
Yeah,
in the courthouse.
yeah, but we kind of understand what you're talking about is, you know, how difficult litigation can be. I mean, what made it so bad for, or what was the breaking point for you when you realized that mediation was really how you wanted to focus your attention?
Well, I was really finding that in even the most high conflict cases where they couldn't agree that today is Tuesday, they were able to, in mediation, come to comprehensive and creative agreements that really were narrowly tailored to the needs of that particular family and addressed their particular needs in a way that a judge really couldn't do, in the sense that a judge doesn't have the ability to pay the time, to give the time and attention to a particular family that has scheduling concerns because they've got a superstar athlete child, or they've got a special needs child and the parenting schedule needs to be situated in order to accommodate those special needs. And so, you know, in the context of mediation, you know, you are able to, whether it's all in the same room together, and I use the word room lightly because we could all be in the same session together, or it could be in breakout sessions in Zoom, or through a series of, you know, through shuttle diplomacy, come to these comprehensive creative agreements that really work for families. And I was finding that the orders that were being imposed by the judge were not comprehensive enough and were not tailored to the needs of that family, and really left a gaping hole in a lot of instances, and left ambiguity, and required people to go back to court to either modify or clarify the orders that they were receiving. And so the process just continued and continued and continued. And your client isn't happy at the end of the day because they're just continuing to rack up fees. And they, in going through the process, one of the most challenging parts for a litigant is that lack of certainty. And having that lack of certainty carry on and on and on is incredibly painful and challenging for them.
Do you think that more gets done with just you as a mediator and you kind of cut the attorneys out? In other words, like, are the lawyers kind of the ones that are not trying, but, you know, like with all of our safeguards built in, like we're trying to protect our clients so much that we ultimately put our client in a position where like no agreement can be reached because we're trying to be so careful?
Well, in some instances, I've seen attorneys that fail to set proper expectation levels. And so they back themselves into a corner and they're unable to compromise out of that corner. You know, that happens. And then there's just this, you know, lack of predictability with judges. I mean, you've got how many judges in the domestic relations division that on any given Sunday could give you a different result. And so, you know, for the litigators, they are doing their best to advocate on behalf of their clients, and kudos to them. But there is that lack of predictability. So to answer your question, I think that's absolutely correct, that less gets done in a longer amount of time in a courtroom than in mediation. I mean, you can, you know, work through an entire holiday schedule in a matter of 2 hours if you can get people focused and understand what the needs of their holiday schedule may entail.
I think that's correct if you've got motivated parties to mediate. But let's say, you know, you've spent all this time. I mean, I think, because we spend a lot of time obviously talking to our clients and try and settle it, but you talk and you talk and you talk and it's just not going nowhere. So at what point in time do you think, like, God, we just have to pull the plug on this and go to court and get a ruling because you just got one party who's just not going to do anything?
Absolutely. I mean, there will always be those cases that mediation just isn't working, you know, because somebody is so entrenched in their positions, they can't see the benefit of a compromise. Their war chest is so deep that they could litigate and litigate and litigate, and it's not going to affect their financial circumstances. Or they just want to extract a pound of flesh from their spouse. And in those instances, you know what? Go ahead, go to a judge, get the order, take it to the limit there, because mediation won't work for them. But I do find that even when somebody is reluctant to get involved in the mediation process, once they're in it and they appreciate the open and frank conversation that can occur in mediation, and also the streamlined nature of the process, so that you're not doing unnecessary discovery that is unrelated to the issues in that particular case. And you're not waiting for this party to talk to this attorney, to talk to this attorney, to talk to that party, and then all the way back to the other side of the equation. I mean, it's faster paced, and you know, we're moving and grooving to get it done.
Yeah.
This is not a process that gets finer, you know, with age. It just doesn't.
Right.
What would you say is your number one tip for litigants who are going through mediation to make the process run smoothly?
I think getting a clear understanding of what their, two things. You said one, I said two.
That's okay.
Number one, to get a good understanding of what their rights are and what their responsibilities are before they walk into the process, so that they can have a proper expectation of, you know, range of expectations in terms of how the case may get resolved. And so that is helpful in terms of beginning the process. Second to that, maybe not second to that, equally important, it's that everybody's participating on a level playing field in terms of access to information. So, you know, in a married couple, there's a division of labor that's totally fine and totally appropriate, and somebody may be more in charge of the finances, and somebody else may be more in charge of scheduling extracurricular activities and school enrollment. What those two buckets require of each parent, both parents need to understand. Instead of just saying, I want 50-50 time, or I want equal decision making, understand what that actually means. Understand what the finances are, so that you can come in and have a good understanding of what it is that you're actually asking for.
Yeah. And so I guess if I trim the fat off of that suggestion, it sounds like having an attorney to assist them, maybe not necessarily in the process in the room, but at least to be advising them on the sidelines is integral, so that they know what they're negotiating. Is that fair?
Completely fair. And, you know, in my preliminary conversations with the parties, if I'm hearing that somebody may not have that equal access to information, or an equal understanding of what, for example, their financial picture is, I may suggest to somebody, go pay for a couple hours of an attorney's time, just so you have that understanding, and this process can be most successful. Because, you know, knowledge is power, and they need that knowledge in order to effectively participate in the process.
Yeah.
I usually like to have them, you know, involved with me a little bit, because I've had an agreement come back once in mediation where my guy only got 20% of the marital estate. And I was just like, what happened? Why did you only get 20%? And he goes, he's like, he just got tired, you know? And I'm like, well, that's insane. You know, like, we're not gonna get 20% of the marital estate for no reason. You know, we're gonna go, I mean, why wouldn't you get 50%? I didn't understand that. And, you know, so then it was like, after I talked to him, I felt like I had talked him out of the agreement, which I felt bad for, but I just didn't think the agreement was in his best interest. Right. So you don't really look out for the party's best interest. You're just trying to get an agreement. Is that right?
Well, yes and no. I mean, I'm not there to advocate on behalf of either party, but given the experience that I have and the background that I come from, you know, I have an understanding of what's reasonable, what's not unconscionable. And, you know, if I feel like somebody is making a deal because, for example, they're tired, I'm going to end the session and, you know, ask everybody to go back to their corner. Balance. You don't want to, you know, interrupt the flow of the session, but you also want to make sure that everybody's going in eyes wide open. And right. So, you know, I'm not advocating for somebody to get a specific percentage of the estate, but I also know what a judge would and wouldn't stamp. And so I can provide that evaluative perspective.
Yeah, so you can tell somebody, well, look, this is unlikely to ever get done this way. like we always used to get in the past, I don't know why I don't seem to get them anymore, but people would call me and say, you know, he's not going to visit and I'm not going to take child support. And I'd be like, you know, well, that's not going to happen because, you know, for all the variety of reasons. So do you ever have that situation where you just have to tell them this is something the court's just never going to sign?
Right, absolutely. And, you know, and so if people are taking unreasonable positions in a mediation session, you know, I can provide the perspective to say, look, you can take that position if you want. These are the attorney's fees you're going to incur as a result of the position you're taking in all likelihood. This is the amount of time that it's going to take to get there. You know, I think that, you know, a mediator who is simply playing telephone that says, he says this and she says this, is not providing a benefit to the parties. You know, I think that they need somebody who is going to provide that evaluative perspective to help move them through the conversation.
And really, that's what mediation is, right? You're just facilitating a conversation, because there's mediators out there that are not lawyers and don't really know, I guess, the family law and how it works, or like you've been boots on the ground in front of these judges. So I always look at it as an advantage of having a lawyer as a mediator.
Yeah.
I completely agree. You know, there are a lot of very qualified professionals, mental health professionals that do a lot of mediation that are amazingly attentive to some of the parenting issues that couples are facing when it comes to finances or some other circumstances that are more nuanced and require a better understanding of the law. You know, it becomes quite challenging when you don't have the ability to provide that evaluative perspective. Because then you really are kind of just a straw man in the middle, monitoring the conversation, but you know, I'm not sure you're providing a benefit.
And how are you paid? Who pays you? Is it one party? Is it court ordered? Do you have a retainer agreement?
I have a retainer agreement. It's an agreement to mediate. As far as how I'm paid, it depends on the circumstance, whether it's by court order or, you know, one party pay, both parties pay. It just the circumstances depend. I get paid by the estate. Just depends.
I often tell my clients that, you know, if people own your agreement, and maybe that's not the right term, but if you own that agreement, you came up with it, you were part of it, what makes you think a guy in a black robe is going to know anything enough about your family to tell you what to do?
Jan, I couldn't agree more. I mean, you know, if you have the control over your agreement and you are the one who's going to be living and dying by it, you know, the likelihood that you're going to follow it and, you know, be compliant is so much greater than somebody who's imposing it upon you.
I wonder where they got that, you know? You always hear that. I want the judge to decide. I'm like, why?
I know.
Like, why would you want that? You know, I say that all the time.
And people really think that there's this being, like this great being up there who's going to make this decision, and it's going to be so great. We've all been in trials. All four of us have been in trials, and we get that judgment. And like you said earlier, Alex, it's incomplete. It doesn't take care of the things that the family really needs. And then you're back to court.
Yeah.
And then
I think they want to be right. You know, it's just like if the judge says that, you know, my position was correct, see, I was right. And the right can be more important to them than the agreement, which, you know, I think it's just got to be the emotions that are in the way because.
Absolutely. And look, it's an incredibly emotional process. So, you know, I don't fault those individuals who really want a judge to decide. What I would ask those individuals to do is take a step back, ask them what their best case scenario is. So what is it? You want somebody to get a slap on the wrist? Or what is it that you're actually looking for? Because as all of us know, a courtroom is never going to be a place that makes somebody a nicer person, a more generous person, a more compromising person. And so if you think you're going to get that type of relief from a judge, I would say you should probably get involved with a mental health professional to help you work through the emotional issues that result from getting divorced, because you are not going to get that kind of satisfaction in a courtroom.
But you see like the court TV, and like Judge Judy is just like, like she like reams the other guy when he's done wrong. And I think, it sets up this horrible perception of what court is like, And I tell
we're all a victim of having watched too much Law and Order, and you just don't.
Or my favorite, Boston Legal with Spader, is like my favorite.
Choose your legal drama, but it just ain't that way when you get to the Daily Center.
Yeah, and they think
in
it
like
is.
one courtroom.
Fight with each other. It's like, we don't do that, It's like, but.
Wasn't that guy we ran into in St. Louis on Boston Legal, was that the guy that you liked so well?
No, it was Spader is the one I liked, but I also liked Denny Crane, and we met him in Springfield, remember? And then I went up to him.
We ran into Denny Crane in Springfield, and Kim watched the show, and she saw him from across the room. She was, oh my God, it's Denny Crane.
They had a lawyer conference. I ran into Denny Crane. I was so excited.
Tell him what happened.
Yeah, so I go and I sit next to him, and I said, I love your show. And I said, I'm here at this lawyer conference. And I wanted to tell him, like here in my dream of dreams, I thought he's going to be like, oh, cool. Let's go up to the convention together. And like we could walk around together. Like I'm thinking, oh my God, we have Denny Crane. It's going to be great. And he just deadpan looks at me and he goes, please leave me alone. And I was like, oh my God, really? Like I was crushed.
She was devastated. She was absolutely devastated.
Oh my God, it was horrible. We do have a question here, though.
That somebody wants to know, when do I need an attorney versus a mediator?
Yeah, there you go.
Is there a guideline where you say, okay, this is for a mediator and this is for an attorney? How would you answer that?
I would say that, if they have that understanding and they have the knowledge of what their rights are, what their responsibilities are, and both parties are on the same page to try to resolve this in the most efficient before you spend a boatload of fees, in the litigation path. From my perspective, there are kind of 4 times that I would say to somebody, consider a mediator. Number one, when a case starts, because as you all know, cases often begin with a boom, and there are some immediate issues that really need to be addressed, right when a case starts. So, an immediate temporary parenting schedule, an immediate understanding of who's paying what bills. And, those putting a Band-Aid on those issues really keeps the temperature down. The second time I would say consider mediation is after everybody's done with their discovery and understands, the ins and outs of their finances and, what a parenting schedule should look like. The third time in a case that I would say consider mediation is right on the eve of trial, because as you all know, you're about to dive off into the abyss. And in terms of finances and your emotional health, it might be a good time to try to reach an agreement. And then the fourth time would be after a case has concluded, when it's post-judgment and there needs to be a modification of a parenting schedule or of support. These are all good times to say to your spouse or former spouse, hey, let's agree to disagree, and let's figure out how we're going to get to yes in the most efficient way possible.
We have quite a few questions, so this is good. They want to know. I'm sorry, go ahead.
The question here is asking, I'm trying to get service. Do I need a mediator or a lawyer? Well, a mediator is not really going to help you get service. That's when you need your lawyer to step up and make sure that they can find and do proper service. The mediator is really to help two people come to an agreement. So if you don't have the other side, you're having problems serving the other side, the answer to that question is you need a lawyer for that. And that's certainly something that we could help you with. But mediation, like you say, comes in when people are ready to sit down. But the thing of it is, people don't realize they're ready. I think nobody wants to make the first move because everybody's so angry and so entwined in the badness.
Yeah, I
But
had a
that's-
client just
but that's-
yesterday say something about, you know, the mediation, like, am I allowed to talk to him and try and settle issues? I'm like, yeah, of course you are. Like, why would I'm sorry if I ever gave you the impression that you couldn't speak to him, you know? And they seem to think that if I speak to him about a settlement position, it can, you know, it could be used against him. And I explained to him under the rules, I can't, you know? And please, you know, reach an agreement if you can.
Certainly. And you know, fear or concern about getting the process started, that's on the mediator to help smooth those edges, make people feel comfortable getting started in the process. I have preliminary calls with both sides to help people understand how the process is going to work, answer their questions. I ask for feedback from them in terms of, you know, what are personality things that you think would help me to know and helping you guys navigate this conversation? You know, not necessarily landmines to avoid, but just to be aware of things that you think would help me work through these issues with you both. And so I give both parties that opportunity so that they can both feel comfortable with me as well as what the process is going to look like.
Yeah. Keith is back this week.
Hey, Keith.
You don't know him, Alex, but
He's
Keith
saying he's had a bad experience in mediation.
Yeah.
I mean, are there people that come out and say, the mediator told me this is the best that's going to happen? I mean,
Yeah, that's what he writes. He said, I was offered minimal time with my children, and I don't understand necessarily that comment, because you either reach an agreement in mediation or you don't. I'm not aware.
And the mediator isn't the one making offers, right? I mean, that she's here communicating offers and, you know, provides some perspective in terms of what those offers may or may not entail. But as a mediator, I'm not imposing any order, or the ideas might be generated by me, but it's not, the offer isn't from me.
Yeah.
And people sometimes think you're the decision maker. You're the one who's going to tell them how it's going to be and what's going to happen. And maybe you're going to go back to the judge and tell them, you know, what a great person you are. They want to unload all the bad stuff about the other party.
Well, you know, I do play a little bit of a therapist in my role.
All
but,
of us do.
You know, with that being right. But with that being said, there is a blend of alternative dispute resolution called mediation arbitration, where folks can decide that they can attempt mediation with me, and if they choose to, have me decide, because they really want to encapsulate the process and get it done. And I've done that before.
Okay.
Has that worked out okay?
Certainly.
So they agree that you're going to make a decision.
So, for example, in a post-judgment case where there is, you know, child support reconciliation or expense reconciliation that needs to be done, and they're going back and forth with the numbers, and so, you know, they may ultimately say, Alex, you just decide. If they
Are you listed in MSAs or JPAs or whatever we call them now as a mediator that they go to if there's trouble?
Certainly.
Oh, great. That's a great role.
And in addition to being a mediator, I also serve as a parenting coordinator.
I was just going to ask that.
And the way to think of a parenting coordinator is sort of like a referee. So day-to-day parenting type decisions, not parenting decisions on ultimate issues like which school is a child going to go to, but you know, who's going to pick up Tommy from soccer practice, and can you know, dad have an extra overnight because of a family reunion? Those types of decisions that oftentimes wreak havoc on a couple, you can defer to a parenting coordinator to really ease the communications. And, you know, I function in that role in many cases.
Can you be called as a witness ever?
No.
Settlement negotiations, right?
Correct.
Yeah.
Well, what's the trend? Where do you see the trend going? Is it more mediation and less divorce? Are people really wising up to the fact that mediation is the way to go?
I I think so. I think people are seeing the benefits all day long. And, for all of the reasons that we've been discussing for the past 30 minutes, people really do see the benefits. And in addition to that, when I started practicing, the mediators were all former judges, primarily former judges, and were really quite expensive. Their rates were really quite expensive. So, the efficiency was sort of lost when you brought another professional into the room. My rate is such that you can't help but say, let's give this a whirl, because what we're going to spend in lawyers and on trial far exceeds what we might save if we reach a resolution with Alex.
How do we prepare people for mediation? Because I think in the beginning, it's a little hard. There's so much emotion. It's almost like it has to die down just a little bit. Anger, stuff like that has to be looked at, or counseling has to start. Something has to do to get them even in the same room. And sometimes I have such high conflict people, I don't even know how I would ever get them in the same room.
So number one, they don't have to be in the same room. And so if the fear is being in the same room, that doesn't have to be the case. Number two, in terms of preparation, completing a financial affidavit and getting a financial affidavit from the other side so that the complete financial picture is known is key to having the financial discussions. And as it relates to the parenting matters, walking through a skeleton parenting agreement so that people understand all of the various issues that are going to be addressed in the mediation. So a regular parenting schedule, a holiday schedule, a vacation schedule, and making sure that people understand that they need to think about, what are my traditions? What are the things that are important to me? What are my spouse's family traditions that are going to be important to him? How can we bring those together so that all of those traditions are honored in a parenting agreement, and make it work for both of us?
Yeah. Well, here's another question. What about when a third party gets in the middle? In my divorce, my wife's mom is the driver. She thinks I married her.
Wow,
So,
then what?
Yeah.
Hi, Gerardo.
So I don't allow other individuals in the process. The confidentiality and the agreement to mediate is among the parties, myself, and perhaps their respective counsel, and that's it. Certainly, people have their support systems and their confidants who may help them through the process. But for the reasons that particular case, they may want their mother involved, the other side certainly doesn't want their mother-in-law or former mother-in-law involved. And it really challenges the effectiveness of the process if I have these other players in the game, so to speak.
Yeah, and Gerardo, you could probably use...
Go ahead, Jen.
Sorry, you could probably use that, Gerardo, to your advantage. If mom's with your wife every time she meets with her attorney, she's losing her privilege, and that mom can testify about everything that they're talking about. So I mean, you got to be really careful when you involve a third party and lose that privilege.
Yeah.
Certainly.
Sometimes though, we just have people that are, I don't know, I don't want to say meek. That's maybe not the right word, but they have an inability, either their personality or just the length of time in that marriage and the role in that marriage, to just kind of stand up for themselves. So I see, like, sometimes my client has their sister involved, and I know that sometimes they can raise the level and the pain, and especially a new spouse can really raise the new pain. But I don't know how to deal with that either when I've got a client who's just so under, like the level is not the same. And how do you mediate if you've got one really strong personality and one kind of down here?
It's challenging. It's challenging, but what's critically important is that everybody feels heard and that everybody feels that they're able to articulate their positions, whether it's face-to-face in a room with their spouse or former spouse, or through me. And oftentimes it's more easily accomplished through me, and I'm there for that. And I understand that. And again, having been in this practice for so long, those personality traits are easy to recognize, in the sense that I can see when someone's feeling stifled in their communication, feeling inhibited in their ability to articulate their position. And, you know, and it's my job to help them work through that.
Yeah, because they agree when they're sitting there, and then they go home and they talk to the person who's kind of running the show, and then I get this email back, I'm not in agreement with anything. And I'm like, oh my God, we spent all this time, you know,
Well,
but it's that third party who's got the, you know, the input now. You can't agree to
and there's
that.
inevitably going to be some buyer's remorse after a mediation, where people don't feel that maybe they got everything they wanted or they wanted something different. And then I just ask people to sort of sit with it, and recognize the reasons why they did reach that compromise. And oftentimes that's the key.
Yeah.
You talked about shuttle diplomacy. Tell me about that. Do you think that that only works with certain clients? Is that the norm?
It is, for certain cases it works, for certain cases it doesn't. For certain cases where they're able to calmly have a discussion and argue their respective positions face to face, it's not necessary. But when I feel the conversation will be better had in separate rooms, that's the way I'm going to conduct it. You know, and so the minute somebody flies off the handle, I've got people on, you know, back in their respective corners, because, you know, I want to, it's again, part of my job to keep temperatures as low as possible when they're already running pretty hot.
And how long is like a maximum session? Because I know it's good to get a good piece of time, but when do you cut that off?
Well, so that's an interesting question, because in person, I was finding mediation, you know, a 4 or 5 hour session, nobody would blink at that. Over Zoom, I'm often finding that, you know, 2 to 3 hours is really the sweet spot, and people really lose stamina staring at a screen, you know, for much longer than that. And that's fine. So shorter sessions, and perhaps more frequent. What I do not like is when there's a long delay in between sessions, and people either forget what they were talking about, or, you know, just lose sight of, you know, where we were going in the discussion.
Wow. Great information.
We feel like that when we have a trial, and the trial starts for 2 days, and then like a month later it picks up again. You're like, oh.
Or 6 months later, as you probably remember, Alex, when you have a trial, sometimes it can go for a year and a half. How
It's
do
horrible.
people operate like that?
Yeah, it's hard.
Well,
Hard on everyone.
It's a good way to undercut that.
Yeah.
Absolutely.
Yeah, don't go to trial.
You won't find me in the Daily Center again. I promise.
I don't
You
know
may not
when
find
we're
us
gonna
there
be-
either.
I don't know when we're going to be in the Daily Center again.
Good point. Good point.
Right.
Yeah, it's so much more civilized this way to me.
Yeah.
Yeah, it is, and I also realize that I go to court out in outer line counties they don't have elevators, so they're in person now, but you have to still wear a mask. And I didn't realize how much I must be a lip reader and didn't even know it.
Right.
I have trouble understanding people when I can't see their mouth move.
Me too.
Well, maybe they're mumbling.
The whole new world we're living in.
Yeah, so I'm trying to get used to that. I don't like wearing a mask for hours because you read people too, right? When they're testifying, when they're answering questions, or you can read. It all goes away with the mask, so I don't like it.
Jan does not like it.
I don't like it. But anyway.
I'm a lip reader too. I mean, I've got people gesturing to me now when I'm walking down the street because they'll say something and I'm like, what? 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 And they're like, I like your mask. I'm
Do you
like,
have something
oh,
special?
okay.
Do
What?
you have a special mask?
I whatever is laying on my washing machine is what I grab, and there's like a whole bunch of. There's a Friends one, like the TV show. There's some Disney character mouths. Like I have like a Mickey Mouse one because the adult and kids ones came together, and I got some for my kids. So yeah, there's some funny masks for sure.
Yeah.
But
it's my understanding that if you walk into like Walmart or Target, there's like racks and racks of masks now.
Yeah.
ew.
it's like a fashion. It's a piece of your fashion now.
Yeah, right. Back to school masks.
All right.
Well,
Well,
Alex,
this is
did you want to tell us any last concluding thoughts, how people can reach you, something like that?
Certainly. My website is jacobsonmediationgroup.com. All of my contact information is on the website. I'm happy to have any conversations to answer any questions about my background, my practice, or how I might be able to help anyone through divorce and family law related issues. Please feel free to reach out.
Yeah.
And I also wanted to thank you guys for having me join you this week. This was great. Thank you for tolerating my setting today.
No problem.
fine. Yeah, it's fine. And we also have your contact information. If anybody's looking for it through us, we've used you, we've worked with you. We are fans of your work. And so enjoy the rest of your day and be
You guys too.
See you again. And happy Tuesday, everybody.
Happy Tuesday. Thanks again.
Bye.
Bye, Alex. Thank you.